John is now without a lawyer and less than 3 months away from his jury trial. He has no access to the public defender system, no attorney to represent him whatsoever, and he has to figure out exactly how he's going to move forward as a pro se defendant. Welcome back to Corrupt Clearfield, and a reminder to all of you that you can follow along with the official documents that we will be referencing here via the Dropbox link at corruptclearfield.com. Now, something interesting to point out first off. If you remember me talking last episode and a couple episodes prior as well, Stephanie Cooper, his former attorney, she didn't file any of the documents that she said she was going to file, the ones that John petitioned her to file, and she never got back to him either. John had been keeping an account of all the times he tried to contact her, and she did not contact him back. Now, you have to announce what sort of defense you're actually going to be doing when you are in a jury trial, so that way the prosecution knows exactly what to prepare for. John was going with an alibi defense. An alibi defense is pretty self-explanatory. I was not there when you said I was there because I have alibis who can give sworn testimony and sworn statements proving that I was not there. John gave Stephanie Cooper all of this information. He actually correctly formatted it and gave it to her exactly as you're supposed to give it to your attorney so that they can then turn it in and submit it into discovery. Stephanie did not turn it in though. John, of course, at the time didn't realize this. So he was completely caught off guard when he was given a certificate of service, which is a certificate saying that you have been served a legal document pertaining to you and your case. This was a document called a motion in limine, basically just a motion legally announcing something and requesting it of the judge. This motion was served to John on June 30th, 2016, less than 2 weeks before his jury trial was set to take place. Now, outside of the contents of this motion in limine, which I'm about to read to you, you'll find out in just a moment exactly why John was uniquely ill-equipped to actually handle this document when it was delivered to him on June 30th. For now, though, let's go ahead and read this motion in limine and see exactly what the Commonwealth, the District Attorney's Office, is requesting of the judge. Now comes the Commonwealth of Pennsylvania by and through Benjamin D. Baker, Assistant District Attorney, Clearfield County, and in support of the foregoing motion in limine. On August 31st, 2015, the above-captioned defendant was charged with stalking and harassment. The charges relate to defendant stalking his estranged wife. Defendant was formally arraigned on October 7th, 2015. On June 30th, 2016, the Commonwealth was provided with reciprocal discovery by the defendant. Included in this reciprocal discovery are lists of witnesses that the defendant will testify that he was not at the location of one of the events that comprise the stalking charge on August 3rd, 2015. Commonwealth can only conclude that these lists of witnesses are a notice of alibi defense. Then it lists the Pennsylvania Criminal Code for alibi defense, and they say it states, a defendant who intends to offer the defense of alibi at trial shall file with the Clerk of Courts not later than the time required for filing the omnibus pretrial motion provided in Rule 579, a notice specifying an intention to offer an alibi defense. The Criminal Code also states, the notice shall contain specific information as to the place or places where the defendant claims to have been at the time of the alleged offense and the names and addresses of the witnesses whom the defendant intends to call in support of the claim. PA Criminal Code states, if the defendant fails to file and serve the notice of alibi as required by this rule, the court may exclude entirely any evidence offered by the defendant for purpose of proving the defense, except testimony by the defendant, and may grant a continuance to enable the Commonwealth to investigate such evidence or make such other order as the interest of justice requires. Funny that they're intent on serving the interest of justice, but that is an aside at the moment. The Criminal Code also states the omnibus pretrial motion for relief shall be filed and served within 30 days after arraignment, unless the time for filing has been extended by the court for cause shown. Defendant has received no extensions from the court to file any omnibus pretrial motions nor any alibi defenses. Furthermore, defendant has not shown any cause to the court in support of being granted an extension to file an alibi defense. Given what the defendant has averred in Attachment A, defendant must have been aware of this defense prior to his formal arraignment. Therefore, the notice of alibi defense is improper because it fails to adhere to the rules of criminal procedure. Due to the defendant's improper offer of an alibi defense and inability to file a proper notice due to the deadline being passed, the Commonwealth believes that it would be improper to grant defendant the ability to offer an alibi defense at trial in the above-captioned manner. Because of the aforementioned reasons, the Commonwealth objects to any witnesses listed in Attachment A giving any testimony in regards to an alibi defense on behalf of defendant. And of course, this motion in limine is granted by Judge Paul Cherry. Now, for those of you who, like myself, are not legally inclined when it comes to speech. Essentially, what this document is calling for is John to not be allowed to interview any of his alibis, cross-examine any of his alibis when he is defending himself as his own attorney at trial. These are documents that he provided to Stephanie Cooper that she failed to file on his behalf. He thought they were filed and that he was going to be able to call his witnesses to the stand while he defended himself, but because Stephanie Cooper did not file those documents with the court, John had no recourse at this point with which to proceed with his alibi defense. Essentially, he's going on an alibi defense without being allowed to call any of his alibis, and the fact that the judge would sign off on this is absolute insanity. In fact, a number of legal minds that I have spoken with have told me that when a defendant becomes a pro se litigant, which means they are representing themselves, whether by choice and especially because of circumstance, the judge will generally offer and afford them exceptions beyond what they would normally offer an attorney in the interest of justice, to make sure that justice is served, to make sure that a fair trial is had for all, and without expecting a pro se litigant to understand and adhere to the rules directly. So even if John had never delivered those documents to Stephanie Cooper, even if he had not decided on an alibi defense until this point in time, it is within the realm of reason that a different judge in a similar situation would allow John to still file an alibi defense because he was a pro se litigant. But none of those things even matter because his attorney, his former attorney, was supposed to file those documents. The judge was aware after John told him that she had not done anything, that she did not file those documents, and the judge, Paul Cherry, still decided to grant this motion in limine to stop John from interviewing any witnesses in cross-examination during his own trial where he was being forced to defend himself. This is absolute abuse of the judicial system to the highest degree. But I digress, and we will move forward. I've also got besides the actual motion in limine, by the way, folks, you can check out the document that shows John had all of his ducks in a row, and he had all of his alibis formatted properly with their home and cell phone numbers, with their addresses listed out properly. This is the document that he provided to Stephanie Cooper that she did not file. So you can take a look at that for yourself. I've also got some witness statements from the various folks who were going to offer up an alibi defense. I got notary seals from the Commonwealth of Pennsylvania showing that they are official documents, but not allowed to be permitted into the trial. Now, this is where things get absurd. So John's trial is at the beginning of July 2016. He's already struggling with trying to prepare his own defense. 78-year-old man, lawyer abandoned him, drained him dry, took all the cash he would have had to pay an upstanding attorney, and he doesn't have any access to money because, remember, he tried to get spousal support, having no access to their financial institutions and no access to their shared money that they had been using and distributing amongst themselves previously, but now Tara had sole access to, because the spousal support hearing determined he was not eligible to receive any of that money. So he is operating on the most limited of limited circumstances, and then he is arrested once again. On June 17th, 2016, a little less than 1 month before his jury trial, Officer Tracy Winters is called out to John's residence, and I'll go ahead and read her affidavit of probable cause. You can decide for yourself what this sounds like. On or about June 14th, 2016, so here we have again somebody being notified and then not doing anything until 3 days later. Very strange procedure. On or about June 14th, 2016, your affiant, Deputy Tracy Winters of the Clearfield County Sheriff's Office, was advised of a possible PFA violation that had occurred. The plaintiff in the PFA, Tara Ann Gill, stated that she has an extended PFA order against John Gill, which became effective September 29th, 2015, and does not expire until September 29th, 2018. On May 25th, 2016, the defendant posted from his personal Facebook page where he goes by Jay Gill. Here's what the post said. This is verbatim. The need for prayers concerning the David and Goliath trial. It is a very fierce, white-hot, 3-part war. At this time, please pray with me for the Thursday, May 26th, that God will prevail and reveal his perfect will to everyone. Now 6:16 and 7:8 concerning Goliath and his reign. Another post on the Bishop's Corner, Truth vs. Tradition, was posted May 25th, 2016, and says a similar thing with the addition of, everyone please continue to pray for June 16th and July 8th to end Goliath's reign. Thank you so much. A third post, basically the same thing. Under subsection 7 of the PFA order, it states, defendant is prohibited from having any contact with the plaintiff or any person protected under this order, either directly or indirectly through third parties, by email, cell phones, text, IM, IM blogs through social networking sites, including but not limited to Facebook, MySpace, Twitter, or by any other electronic means, including no postings of any kind about the victim. The victim/plaintiff of the PFA, Tara Ann Gill, provided your affiant with a 6-page victim statement. Beginning on page 2 of her written statement, the victim writes the following, beginning on line number 17. And then it includes what Tara said. This is absolutely asinine. This is what Tara entered into the record. In the book of 1 Samuel, chapter 17, the Bible explains the story of David and Goliath. John Joseph Gill Sr. is portraying himself as David, the son of Jesse. Furthermore, Mr. Gill is portraying me as Goliath, a giant who is taunting and harassing and repeatedly asking for the armies of Israel to provide a man from their armies who will fight him, as referenced in 1 Samuel 17, 8-10. In actuality, Mr. Gill is the aggressive party, constantly posting on Facebook, speaking to others about me, stalking me either himself or through third-party family members and friends. I have not had any contact with Mr. Gill since departing the marital residence late summer of 2016, except when he is violating the multiple PFAs and or during a court-related matter requiring my presence. Further, Mr. Gill, for unknown reasons, has expressed a long-standing jealousy of my family's lineage, part of which is Jewish. Quite ironically, my grandmother's name is Jessie. I am so concerned about the apparent instability, unpredictability of Mr. Gill's deviant behaviors and his mental status. It is quite clear to me that Mr. Gill's reference to David and Goliath as told in the Bible is a direct death threat, not only to me, but to my children as well. Mr. Gill has verbally threatened my children in my presence on numerous occasions when I was still residing in the marital residence. I say this because in 1 Samuel 17, 25, 34, 37, 40, 46, 49 through 51, 54, and 57, the scriptures directly reference how David is going to kill Goliath, the giant, and that he stabs, in parentheses it says mutilates, Goliath and cuts off his head with a sword. Further, David takes the head of Goliath with him for all to see, putting the severed head on display, including King Saul, king of Judah/Israel. David did all of this in the name of the Lord of hosts, 1 Samuel 17:45. I am so concerned, frightened, upset, and in fear of losing my life to this radicalized nut for multiple reasons, with many exclamation points afterwards. One, in 1 Samuel 17:40 and 49, David chooses smooth stones, one of which he uses to hit Goliath in his forehead, knocking him to the ground. Mr. Gill always kept 5 bullets in the pistol he kept under his side of the bed, loaded and ready to shoot. The victim plaintiff continues on, explaining that she believes Mr. Gill is a threat to her and her family, as Mr. Gill himself or his family members continue to harass and stalk them for nearly 2 years, and believes Mr. Gill may have taken out a contract on her life. The victim plaintiff also writes in her statement that he has tried to take my life on several occasions and believes he wants her dead while still legally married on paper so he can claim her medical disability settlement monies. She believes Mr. Gill is a ticking time bomb ready to explode, and that Mr. Gill is trying to intimidate me regarding the upcoming court dates on June 16th and July 18th, 2016. Should be July 8th, I suppose. 2016, I believe that's intimidation of a witness. Further, Mr. Gill has shown he has no boundaries because last July 2015, he repeatedly drove around the parking lot of the church I attend, frightening both of our lady greeters who are witnesses at the July 8th trial and are still afraid of him to this day. Based upon the above information obtained from the 3 Facebook pages, as well as the written statement of Tara Gill, your affiant, Tracy Winters, requests a warrant be issued under, and then it says the Pennsylvania Criminal Code, indirect criminal contempt for violation of the Protection of Abuse Order. Ladies and gentlemen, common sense has left the building. I don't know what else to say to that. Please, at this point, pause the podcast and read the documents for yourself in the Dropbox folder. Read this document for yourself. This is asinine. How this makes it into an official document with the power to ruin a person's life is beyond corruption. It is evil. Pure evil. A couple of questions stem from this as well. Some just logical procession of facts questions that I think have to be asked. First of all, how is this Facebook post even about Tara? Everybody knows that the David and Goliath story is used in a metaphorical sense, and it's not just used that way by churchgoers. Sports announcers all the time talk about how an underdog defeating a better team is like a David and Goliath upset. A person taking on a company in a court battle and winning a large sum of money is like a David and Goliath victory. Nobody dies. I would contend that 99.9% of the times that a person in human history since the event occurred has used the metaphor of David and Goliath for something in their life, they did not literally mean they hoped that somebody would murder someone. John. Yet that is exactly what is entered onto the record here and being used to arrest John. He's arrested as a result of using a David and Goliath metaphor, which, if you ask me, probably borders on the line of protected speech because it's a religious allegory. You can't police that sort of language out of a person when they're talking in a spiritual sense. But I digress once again. Why was Tracy Winters advised about this offense on June 14th, but she didn't move on the case until 3 days later, June 17th? Why are there these gaps in time when something has been noted or something has happened before an action is taken? If someone really feared for their life, as Tara believes she is basically on the brink of being killed at all moments by John, wouldn't she be lobbying the police to act right away? It just makes sense. Now, I've mentioned it before, but I'll reiterate it here. A second PFA violation means 6 months in jail. Do not pass go. Do not collect $200. There is no wiggle room, nothing the judge will do. It is just an automatic 6 months in jail if you are convicted of a second PFA violation. Now, for those of you who are astute, this happening on June 17th means that John is less than 1 month away from his jury trial, where he already has to defend himself without a lawyer and is not allowed to use the alibis he was supposed to enter in because the district attorney's office filed a motion that the judge somehow granted. And if this PFA violation were to stick, he would then be in jail for the entire 3 weeks leading up to the jury trial, with no access to any of his documents or resources outside of the jail that he was using to help prepare his own defense. Not to mention, he now has to represent himself, once again, at a PFA violation hearing. The bail is set at a comical $50,000 for a man who is prominent in the community and in over 78 years of living has not committed an offense so much as a traffic ticket. These are the types of people that should not be filling our jails. They should be released on their own recognizance. Him being in jail on a $50,000 bail during the time leading up to his trial is absolutely insane. Thanks for listening to this episode of Corrupt Clearfield. Remember, you can follow along with all of the documents I'm referencing at corruptclearfield.com. Just scroll down and click the link to the Dropbox file. All the documents are cataloged in order as they appear in each episode. You can also help to support this investigation as it continues, and also our family as we attempt to recover from the damage that has been done. You can donate either by going to corruptclearfield.com and clicking the link as you scroll down the page, or you can go directly to paypal.me/crazygaby. That's my broadcasting alias. Again, that's paypal.me/CRAZ as in zebra, YGAB as in Bravo, EY. Thanks for listening. Until next episode.